Pratiksha, and to the CSLG for inviting me here. Delhi has always been, and JNU in particular, has been kind of second home in many ways. When Pratiksha asked me to speak today, I was, like my title, in a bit of a conundrum, because for the longest time, I was so bored of intellectual property and of copyright that I didn't really do anything around it for a very long time. And most of my work has been around more recent work and interests. But because I was working at that point of time on some new areas in copyright which I had not encountered before, it also gave me a little opportunity to rethink in some ways some of the assumptions which I think has informed a lot of the debates in intellectual property. So I was quite excited then to actually look at this question of copyright and the conundrums of culture. And I'm going to focus, of course, specifically on the intersection between copyright and dance, which I think poses a whole set of interesting philosophical kind of problems. But if you look at the map of the debate in intellectual property over the last decade and a half, 2 decades or so, what has really emerged is a lot of the debate in terms of the focus has been on the question of political economy and the question of access. And that's understandably so, because this is a crucial area. The question of what it means to be able to access learning materials, cultural materials, has been in a way at the defining heart of debates around intellectual property. And if any of you have been following the Delhi University photocopy case, it's a clear example of one instance of how interpretation of copyright law becomes crucial in determining questions of access for a large population. But because of the emphasis on the question of political economy, I think what we have really kind of in a way lost out in the last decade and a half is a certain kind of epistemological challenge or a question about the cultural economy question. Because if copyright law is not merely a system of property in that it regulates, governs and administers a set of different kind of relations around ownership and the control of ownership, but is at the heart of it also a legal theory of culture. And I'll try to make the case about why that is really the case. Because if you look at the fundamental question of how copyright makes sense of the object of its regulation, you really immediately led into a zone in which regulation as cultural signification is completely intertwined. There is no distinguishing between the two. In copyright, the question of what is protectable, what kind of protection is granted to an object, and how we think about the question of the violation of rights are constantly engaged in very specific forms of cultural definitions and delimitations, which produce in a way a specific image of cultural practice. Take, for example, one definition, Section 2C of the Copyright Act, which defines what an artistic work is. Section 2C says, an artistic work means 1. A painting, a sculpture, a drawing, including a diagram, a map, a chart or a plan, an engraving or a photograph, whether or not any such work possesses artistic quality. Right? This is a very interesting and an intriguing definition. So an artistic work is defined specifically in terms of delineation of what the constitutive objects are. So painting, a sculpture, a drawing, etc. And then you have an undoing, in a way, of the aesthetic component, because it says regardless of whether or not any such work possesses an artistic quality. I'd like you to keep this in mind, and I'll return to this. Section 2C2 says architecture, and 3, any other work of artistic craftsmanship. So something as simple as the definition of what an artistic work is. For me, the underlying story or the hidden story of the relationship between copyright and the conundrum of culture can be explored through the process in which a certain definition comes into being. And what are the consequences of this? Because it is clear on the one hand that a definition like this would clearly transact in the same world of the boundaries of what is or is not art, as many debates within art history would. And the fact that copyright law cannot accommodate diverse forms of contemporary artistic production is in many ways a given. No law can do that, right? What is less clear, however, is why this state of affairs could have come about, and especially given that copyright tends to be justified as an instrument for the encouragement of the progress of the arts, what the consequences are, right? And this is something that I will lay out through what I see as the conundrum between romanticism and modernism, which is at the heart of copyright law. And I'll come to this conundrum. If you look at the other side of it, the other side of the ideological debate that copyright is now currently pitched at, which is the copyleft movement, I believe that in some ways there's a need to rethink the basis of that as well. I mean, for years I've been very much on the copyleft side of things, advocating the virtues of open access. I'm not flipping around, but I think that what we've left unexamined, much more fundamentally, is the common ground that the copyright and the copyleft movement share, which is really in the question of the cultural assumptions that it has of what constitutes a work, what constitutes authorship, etc. The two, in a way, are mirror images of each other insofar as the cultural presumptions are concerned, even if they may ideologically completely differ from each other in how they think about questions of access, of fairness, and about of sharing. The reduction to an ideological position leaves untouched the logic of the definition of a work and the logic of cultural production that kind of brings the two together. So very often the copyleft movement would be about a different kind of a license. So whether you choose a traditional copyright license or a Creative Commons license, what you really lack in these two positions is a certain engagement with the question of the aesthetic assumptions behind the definition of a work. So what you, in other words, have is at the moment an aesthetic lack, right? So there's a recycling of the fundamentals of copyright even as it attempts to widen ideas of authorship, originality, etc. There is at the same time for me an ethical lack. And what I mean by an ethical lack is that rather than looking at the immanent logic of cultural production and cultural practice, to look at what forms of ideas of ownership, what forms of ideas of sharing might emerge from practice, there is a way in which there is an imposition, in an already normativized sense between copyleft being good, copyright being bad, and vice versa, depending on which position you come in. And both of them seem to me somewhat dissatisfying. There's also, in a way, an inability to deal with an affective kind of, response, which very often you encounter through what I would describe as the language of being upset. Very often when you encounter what eventually becomes a copyright dispute, what you first and foremost encounter is someone being upset about something. Now, what is the nature of this being upset? Now, you can take different examples. You can take the example of someone whose work has not been cited, or you can take the example of a musician or a painter whose work has been used in a way that they are upset about, right? And there is a way in which this idea of being upset lends itself to a much wider discussion of questions of ethics of ownership, transmission, control, ideas of what is proper in terms of propriety rather than what is, property. But unfortunately, given that copyright is the only language that we have of translating the affective world of a relationship that a creator / artist may have to their work into the public world of the regulation of cultural property, it becomes a mode in which a certain kind of a relationship of proximity to one's work gets translated into a vertical relation governed by the law. So it's for a whole range of these reasons that I feel it's urgently important that we reconsider what it might mean to go back into the ontological and the epistemological debate about copyright and try to think about this as a complete reverse, through a completely reverse framework, where we don't begin with either the copyright or the copyleft debate, but we begin with the immanent logic of practice itself. Cultural practices tend to establish in many ways their own codes of conduct. They frame their own rules of access and develop in a way an immanent ethics which are way beyond the scope of legal imagination. If cultural politics is a scene of invention, then the question is what norms do they develop for themselves that do not take for granted a predetermined language of rights and infringement or rights and obligation, but rather how do cultural practices themselves destabilize the ideas of property while at the same time remaining stubbornly insistent on questions of propriety. Propriety for me does not name a set of legislative principles over proper etiquette. Instead, it builds on the economies of care, jealousy, authorship and ownership simultaneously in their practice. Let me turn to one specific instance of how this plays out, mainly through dance and copyright, and I'll come back to some of the conceptual questions that I've laid out. This is a clip from a film. I think it's an eminently forgettable film called ABCD, and I'll just play a small. It's called Anybody Can Dance Sana. I haven't seen the film, but I've seen this segment. What is special about this particular, kind of choreographed move? Except for the fact that the choreographer, Remo D'Souza, attempted to have this and actually had this dance registered for copyright protection, right? And if you look at the interview, he says, I don't want my dance steps to be copied. And the same interview, if you look down there, it says, in the film, Prabhu Deva pays tribute to Michael Jackson by performing his signature moves in a song. And it's this irony of these two different things existing in the same news item. One is, of course, one could give an account of this in terms of hypocrisy. He doesn't want people to copy his moves, but he's happy to copy Michael Jackson's moves. But that's a simple account. The more interesting account really is the question of what is being sought to be protected here. Right? If you were to look at this in terms of choreography, is there a choreographed act which is not embedded in film? Which is that someone else cannot copy my steps? Or, in what way can this even be copied at all or protected at all? Because the question that you would ask is, if it is a dance that is only embeddable in a particular form, or embedded in film in this case, then in what manner can the dance be performed without editing? Or without, is the dance possible to be created without the aid of an editing machine? Right? So what is the nature of this object that is actually being sought to be performed, or sought to be protected? And this question for me is actually at the heart of a much larger problem. And the problem really is that which we've inherited and which the copyright and the copyleft movement recycles, which is the fact that copyright was embedded in a particular technology. It was embedded in a particular history and philosophy of creativity, namely the technology of print and the ideas of literary ideas of originality, ownership, etc. So the problem for me would very simply be that a lot of what we had inherited as dilemmas, epistemological dilemmas in copyright, can be traced back to the fact that, look at all the foundational principles of copyright law, and you can trace it back to a certain idea of paper. So when you attempt to translate these into other mediums, you run into a whole range of problems. For the first 150 years of copyright's history, you didn't even have a definition of an artistic work. You didn't need to. Because it wasn't until print lithography and cheap reproduction that the question of protecting an artistic work even arose. Because till then, an artistic work, of course, could only be copied very literally by huge labors of hand. So what is the dilemma then? The dilemma for me is very simply that if you were to look at two things, the definition of the author and the definition of the work, which is at the heart of copyright law, traditionally the idea of the author emerges from Romanticism. So the Romantic author is someone who creates something out of nothing, is in a way the guiding spirit of the idea of originality in copyright law. Just remember that copyright came into being with the print revolution. Till then there were a whole range of labors that went into the production of a book. But with the print revolution there was suddenly a crisis. The crisis was, how was the author going to distinguish his contribution from the contribution of the binder, the copier, the typesetter, etc. And the Romantic genius of the author emerges as a theory which says copyright is not about protecting the value of the production of a book. It is about the protection of the intangible spirit of the author that resides and moves in and out of the book. So Romanticism, in a way, is that the guiding principle of the idea of the author. If you look at the definition of the work, on the other hand, given the piecemeal fashion in which categories of works which are protectable were added onto copyright law, a lot of what emerges as the definition of the work has very little to do, in a way, with a certain Romantic tradition. A lot of this kind of the bifurcation of the experience of the work as an autonomous experiential unit really comes much closer to a modernist idea of the work. And there is a tension between the two which is in a way irresolvable. And this is a tension that you will see emerging over and over again in many of the debates that you find in copyright law. Let's take 4 principles. So I've talked about the idea of authorship. The second is the idea of originality. Originality, even though it comes from the idea of a certain romantic tradition, for the purposes of copyright law, originality has never been about that standard originality. In copyright law, originality is about point of origin, right? Which means that you only need to prove that it wasn't copied from someone else. Third problem that we have, the idea-expression dichotomy, at the heart of copyright law. Popular opinion about copyright presumes that copyright protects ideas. Copyright has never protected ideas. Copyright protects unique expressions of ideas. How do you draw the distinction between idea and expression? One simple example, boy meets girl, they fall in love, is an idea which if protected would be the end of Bollywood as we know it. Boy meets girl in Europe, girl comes to Punjab, boy follows girl to Punjab in her engagement, and you have DDLG, a unique expression of the idea boy meets girl, they fall in love. But this idea-expression dichotomy becomes very, very difficult to understand the moment you move across the print medium into other forms of cultural practice, including music and dance. Let's take one simple dance step, which is, by all standards, a unique original contribution, Macarena, right? Is doing the Macarena an idea or an expression? Would doing the Macarena with reverse step constitute a new expression of the same idea? Would doing the Macarena in a Ras Garba setting constitute a new expression? Or is it a copy of the existing expression? Is there an idea behind the particular movement of the dance step? Are these movements of the dance step an idea in themselves? How similar should the dance be to constitute an infringement? Where will you draw the line between substantive and non-substantive infringement? My contention is it's impossible to answer any of these questions. The reason being that the tests that have evolved within copyright law to determine these questions are grounded in comparing two books and comparing two kind of, passages, which is why my title of this talk is Dancing Like a Book. Because what happens when you actually look into a number of these dance-related cases is you find that you actually end up staging a debate around cultural practice as though you were comparing two books. Let me turn to one of the most interesting cases in the Indian example. And this is the Shivram Karanth case, which is the background of this is Shivram Karanth, who is one of the leading kind of researchers and practitioners of Yakshagana, dies in 1997. And in his will, he bequeaths his copyright in all his literary works to Malini Malya. And I'll come back to Malini Malya. It's a very important moment. There is a news item that is published in 2001 in the Vijay Karnataka newspaper, which reveals that a Yakshagana ballet that was directed by Dr. Karanth was performed in Delhi, in fact, in honor of Dr. Karanth, right? This gave rise to Malini Malya, the plaintiff, filing a suit against the defendants, praying for a declaration that the plaintiff is the exclusive copyright holder, Malini Malya, in respect of this particular Yakshagana ballet, and asking for a direction for the appellant to pay damages to the plaintiff. At the trial court, they hold in favor, of the petitioner. In the High Court, they again hold in favor of Malini Malya. In the Supreme Court, they reaffirm her rights as the exclusive copyright owner. But on a technical ground, but in any case, since it was an educational institution, they could have claimed an exception under Section 52. But they don't really address this question of ownership and about the status of what it may mean to copy or choreograph work. That question is addressed directly in the High Court. But let me read out to you the specific will that Karanth had left behind, because that's very crucial. If you notice, I said that what he says in his will is that he's left the copyright in all his literary works to Malini Malya. Question is, how does she bring about then a case which is about violation of rights in a choreographic work? Right? Let me read out the will, because it also goes into this question of being upset. The will says, since I left my house, Suhasa, I have been living in a specially built house, Manasa, of Srimati Malini Malya, who has built it with borrowed money at her own cost. She has joined my service as a copyist, and later she secured an employment in Life Insurance Corporation of India. Ever since 1974 till now, in my old age, she has been serving me with exemplary devotion and sincerity. And on this occasion, I must also acknowledge with gratitude that she diligently cared and nursed for my wife, Leela Karan, during her prolonged illness till her last days. And she has cared and looked after me also during my illness, which at times has been quite serious, enfeebling me for long periods. In recognition of her devotion and sincere affection towards me, I have also dedicated one of my novels, Antida Aparanji, to her. I have also placed on record her invaluable services to me in my memoirs, Huchu Mansina Hattu Mukagalu, in 1991. In my opinion, very long, enduring and service that she has done for me. I leave behind my all the copyright in my literary works to her. There's a thing about the other things. For all these services, I hereby declare that after my death, copyright in respect of all my literary works and the right to receive royalties of all my books, she shall be entitled to, and also entitled to print, publish and republish and market the same. Whatever she may earn thereby shall be her exclusive income and property. No one else shall have any rights or claims to the same. So there's a very touching and moving account of someone who's in a way dedicated their entire life looking after Dr. Karan and his wife, right? One can't dispute that she is clearly the legal heir to the copyright in his works in terms of insofar as the literary works are concerned. But what is the problem? The problem is this: if you look in the logic of section 2, which defines different classes of works, you have the definition of a literary work. A literary work is a definition which says a literary work includes, a whole range of things, tables, charts, etc., but excludes and includes computer programs. Then you have the definition of a dramatic work, and a dramatic work includes any piece for recitation, choreographic work, or entertainment in a dumb show, the scenic arrangement or acting form of which is fixed in writing or otherwise, but does not include a cinematographer. So a choreographic work is not defined in the Copyright Act. It is defined as a part of a dramatic work. Now, in the court, what happens is there are two things that happens. One is the contention that's made by the institute is A, Shivram Karant is not entitled to any copyright in Yakshagana because of the traditional form. So even though he may have modified and created a modern version of it, he cannot claim copyright ownership over it. That's the first claim. The second one is that even if he can claim copyright ownership over it, the fact that he's only left Malini Malia the rights in his literary work does not entitle her then to make a claim in regard to his choreographed works, right? Because what they had done was to recreate one of his choreographed works. The court, in a way, brings and establishes two things. The first one is the romantic author. So if you look at the discussion, and there's a very detailed discussion in the judgment on how they distinguish between Yakshagana as a traditional art form and Yaksharanga, which is Dr. Karan's contribution, as a specifically modern invention created by him, in which he is the author. And what is the evidence that they rely on? The evidence that they primarily rely on is Shivram Karan's autobiography and an account of his own process. Now, I'm not going to go into great detail in this, but I just want to show you a couple of the things. So the argument is that Yaksharanga is a reconstruction of a traditional form, not merely the reconstruction, but also the active invention of a new form. They cite Dr. Karan, where he says, to me, tradition is no dead corpse merely to be worshipped for its own sake, like language has to acquire when necessary new words, new meanings, form and content go together. Yakshagana is no exception, etc., etc. They cite pages 168 and 169 of his autobiography in specific, where he talks about what he meant, what he found was a problem with Yakshagana. He says no one was interested in Yakshagana because it went on for hours. What he did was he cut it down and created what he described as a ballet form, right? So they then look at what the definition of a ballet is, and they say that if Yakshagana is like a ballet clearly has an established author, a ballet has a choreographer, and they establish that Dr. Shivram Karan can claim authorship over this, even though it was a traditional form, right? A whole range of other evidence that they rely on. I'm not going to go into that in detail. But what they conclude by saying is, Yaksharanga represents the culmination of 2 decades long effort of Dr. Shivram Karan to restore Yakshagana folk theatre of Karnataka to its rightful place in the world of natural art, particularly in the realm of dance drama. In its concept of total theatre, with dance, music, dialogue and decor all harmoniously blended to create maximum artistic effect, Yakshagana lays equal claim to be amongst the best known dance forms of India. So there is the institution of the romantic author. Second problem is this question of, okay, how do you distinguish between the literary work and the dramatic work, right? So in this case, the court unfortunately makes a very, what Ryle would describe as a category mistake. In a very perfunctory manner, they do a Venn diagram and they say, okay, there are some literary works which can be, or there are some dramatic works which can be read, for example, Shakespeare. And there are some dramatic works that can have a literary component, and they say what is in the middle in terms of what brings the two together shows you that merely because something is a dramatic work, it does not have to be excluded from its basis of protection as a literary work, right? Now, what is the problem with this? The problem with this is simply this. If you take the idea of the rights that accrue to a literary work, that's fine. I have a book. You cannot reproduce the book. You cannot reproduce segments of the book. That's not a problem. But if a dramatic work includes a choreography, what is it that is being protected in a choreography? Is that the same as what is protected in a literary work? By equating the two, by bringing it together, by saying that because it is a dance drama, there are components or there are elements of it which could be protected as though it were a literary work, it collapses the distinction which is specific in terms of the medium of each of these works into one that can be understood in terms that have been set by the idea of the literary work, right? And this is the fundamental paradox. And this is the paradox in the way of the conundrum of copyright and culture. The court says the only difference I see in them is the dramatic work or the play from the text upon which the performance of the play rests, whereas a literary work enables one to read the printed works. Neither of the two can be produced without the imaginative skill of the author. Where do we go to with this? Where we go to with this is back to the Remo case, right? When he seeks protection of his dance, in what manner does he seek protection of his dance? What is the fixation that is required? Is it a notational form, which is I create an algorithm which says my left hand will move up, then I will turn right? Is it the form in terms of a photograph? Is it the form in terms of a video recording? But as it moves across these three mediums, how do you think about the question of the specificity of cultural practice? Can a dance that is recorded on camera be regarded as a dance that was performed live? Right? This is both a question of medium as well as a question of transmission. I remember watching a talk in which someone talked about, Al-Qazi's famous performance of Andha Yug in Lal Killa. Except the only access that we have to that are photographs. And when the person was describing the performance, because he wasn't there for the performance, what he was really describing were the photographs. So he said if you looked at it from this particular angle, except you can't look at it from that particular angle. It's only the photograph that is looked at it from that particular angle. So how do you actually then look at this question of what you were talking about? This goes back into the question that I raised about how does copyright make sense of its objects, of its regulation, right? Let me give you one example of a very famous copyright case on dance. These are the details of the case. So this is a case called Norosian vs. Arts, which came from the Chancery Division in the UK courts. A filmmaker called Norosian had made this film. Norosian claimed that the second was in violation of the copyright of the first. Why? Because the first is about, someone expressing joy through certain kind of jerky dance movements. The second is about someone waiting for the froth of the Guinness to rise in the anticipation, and they seem to perform somewhat similar jerky dance movements. And the argument was that this is a violation of copyright, except that you couldn't claim a violation of a copyright in a film, because the film can only be the copyright in the film can only be violated through a literal reproduction of the film, right? So, if for example I have a movie like Munna Bhai, and I don't have a script for it, I made the film, someone makes a remake of the film, they're perfectly entitled to make that, because copyright does not protect cinematograph films in terms of reproduction of the elements of the film. They only protect the literal reproduction. So in this case, they couldn't claim that there's a violation of copyright in my film. Their argument was different. Their argument is that the film violated not the copyright in my film, but the copyright in the dramatic work embedded in my film. And Anne Barron has a really interesting article in which she analyzes this case, where she says this is in a way kind of significant, because it also takes you into the conundrum of looking at the medium reproduction question in film. But what do you mean by this? It means that the second dance was a copy of the first dance. How would you determine this in a court of law in terms of copyright principle? There are two principles that can come into play. First is the question of copying, literally, the point of origin. Was it or was it not copied? The second is there a substantive infringement? And what is the test for a substantive infringement? What they call the lay reader test. Would two people looking at the same work come to the conclusion that the two works are substantively the same? Right? This is the test. Now, how do you apply that in a case where you're talking about a claim for copyright infringement in a performance which is embedded in a film? Because we go back to the Remo question. The fundamental question is, in what manner could this dance have been performed at all? If you look at the first dance, which is joy, joy in terms of the dance effect of joy is not produced by the human body, it's produced by a camera. So what exactly is being protectable as what is being claimed as protectable in terms of the copyrightable elements of this film? Now, why do I take these two examples? I take these examples to show that there is a way in which what you're really encountering here is not a problem of dance. You're encountering a problem of copyright. There is, however, a residual problem of dance that still exists. And what are the ways in which one may address that becomes the follow-up question. Let me turn now to a very quick history of the relationship between dance and copyright law. Up till 1976 in the US, choreography was never considered a part of copyright, right? Because choreography was, in a way, kind of seen to be a part of a spectacle without any creativity or any social value. So there was no copyright that was granted to choreography, and the history of how choreography enters into the field of copyright law is actually a really fascinating one. There's a fantastic book by Caroline Joan Picard which looks at the kind of intertwined histories of race and gender in the making of the language of property in dance, specifically race. What she argues is that it is whiteness as a property that enables choreography to be recognized as a form of property. Right? So as long as it was in the realm, in a way of, folk forms, black dancers, it couldn't be recognized. It needed a certain figure. It needed the figure of the modern ballet genius who is articulating some kind of a whiteness as a property form that allows choreography to be recognized. The first case, however, is an 1892 case between Louis Fuller and Venice. Fuller was often known as the goddess of light, so this particular dance sequence that she had created, with this dress of hers, her fans included Mallarmé, Yeats, Toulouse, Whistler, Pierre and Marie Curie. So she was seen to be this incredible inventor of the serpentine dance. And she was acutely aware of her commercial value. So she turned to the legal apparatus to claim copyright infringement against a whole range of dancers who were trying to reproduce this effect of hers. The judge in this case in the New York Circuit Court, Justice Liang, dismisses the claim for copyright protection and in his opinion says, an examination of the description of the complainant's dance as filed for copyright shows that the end sought for and accomplished was the illustrating and devising of a series of graceful movements combined with an attractive arrangement of draperies, lights and shadows, telling no story, portraying no character, depicting no emotion. The mere mechanical movements by which this effect is produced on stage are not the subjects of copyright. Surely this dance described here conveyed and was devised to convey to the spectator no other idea than that a comely woman illustrating the poetry of motion in a singularly graceful fashion, and while such an idea may be pleasing, it can hardly be called dramatic. Motion denied. So because choreography was included as a part of a dramatic work, unless there was a narrative element and unless there was a dramatic element, it wasn't seen to be the subject of copyright law. Now, of course, Louis Fuller, being the shrewd businesswoman that she was, said, okay, if you don't give me copyright, that's fine. She ended up filing a number of patents on how to stitch the light into the dress, on the arrangement of the lighting in the stage, and kind of went on to become a big star in her own right on that count. The next major case which establishes the entire relationship between choreography and copyright is the case of Balanchine. Balanchine was one of the geniuses of American dance, hundreds and hundreds of ballets that he had kind of, set into place, etc. Now, unlike Fuller, Balanchine did not have to work very hard at establishing his claim on copyright because it was post 1976, where the narrative element in protecting choreography was removed. So you could have a claim for an abstract dance with no narrative component. Now, what is interesting about the Balanchine case is this. Balanchine himself did not think that his work was worthy of any copyright protection, but his lawyer convinced him that it was. So he wrote a will in which he specified 113 ballets that would be bequeathed to a whole range of people. One of them was his secretary and lover, etc., someone called Horgan. Horgan files a case which becomes the famous Nutcracker case, Horgan versus Macmillan, where Macmillan had produced a book called The Nutcracker, a story and a ballet, which was authored by Ellen Schweitzer, with photographs of Balanchine's version of The Nutcracker. Horgan files a copyright infringement saying that this was in violation of copyright because the dance could not be reproduced, right? Now, in this case, what happens is the court goes into the question of what is the test that you will determine to see whether copyright has been infringed. If I take pictures of a dance, am I entitled or not entitled? The first test that used to be there was the test of the reproducibility. Can I reproduce the performance by looking at the pictures? And the answer clearly to that is no. So they shifted the test and they said this test is inadequate to protecting someone as great as Balanchine. You need another kind of test. The test that they said which is much more reliable is the question of the substantive similarity test, which is a person looking at the dance and a person looking at the photograph, would they come to the likely conclusion that the two are one and the same? And they answered in the affirmative that they are one and the same. Now here again is a problem. In what way is a dance as a performance the same as a dance in a photograph? Right? This is the question of what it means to dance like a book. What does it mean to reduce a three-dimensional act, painting, sculpture, photography, into a two-dimensional form as the only basis of intelligibility, of understanding what it is? So here is a paradox that we have. In the first case, you had a situation where Louis Fuller was given absolutely no protection of any kind, right? Even though she was an innovator, etc. In the second one, you have a situation where effectively the estate is left with absolute control over every element of the dance, leaving in a way, imitators, copiers, no other, kind of entry point at all. Now, the reason why all of this becomes a problem is that if copyright is a technology that's grounded in paper, and dance is a technology that's grounded in the mimetic body, the mimetic body has been crucial to the history of dance. How a body learns to fall, how a body learns a new position that it did not know it was capable of occupying, how does it learn to leap, how does it learn to slide, are ways in which are crucial to a certain idea of a mimetic practice in dance. None of this is translatable on the principles that have been laid in terms of literary originality or idea and expression dichotomy, etc. And if you look within the internal debates on the history of dance, you had a number of debates where they've tried to understand what it means to understand copying within their own tradition. So Trisha Brown, way back in the 70s, in two of her works, Accumulation and Locus, actually lays down the algorithm of every single move that her dancer makes, right, in very precise terms, to say that anyone can reproduce this dance. They can reproduce it on the basis of the literary text that I have left behind. You have other kinds of people, for example, Jerome Bell in 1998, when he makes an entire piece that is really about what it may mean to create a dance out of nothing but quotations. But all of these are practices which are in a way very different from the idea of what literal reproduction or comparing of a literary work might be. It requires a certain understanding of the mimetic body which is very different from the way that the quotes attempt to understand it. William Fawcett has something which is called improvisational technologies, in which every single component, and he actually is the first person who begins to think of dance in terms of open source. He says, what does it mean not only to make my dance available, but to make the components and the building blocks of my dance available. Every single movement and gesture, if I were to reproduce in terms of explaining how the movement is made, and the entire DVD is made available, what would it mean in terms of creating, in a way, a new practice of sharing across dance? And the last example that I want to use is really a fascinating new kind of
idea was find out
the answer of the body, and the body can then replicate every single movement that is made. What he does in his performance pieces are he takes the most complicated and most celebrated dancers from across the world, Martha Graham, etc., and he reconstructs choreographic pieces in which his body, which is obviously very different from that of the athletic dancer, to recreate their movements. So, yeah. So this is an avant-garde Japanese dancer called Nijikata from the 50s, whose dance is reconstructing. I'm sorry, there's some problem translating from the Mac to the Windows in terms of the quality of the video. But if you go online, he's absolutely fascinating. He does this with large numbers of dancers. So 25 people, 35 people who are all in a way wired up and reproducing some of the most well-known dancers in the world. And typically his example would be, he takes a non-dancer and says that, do you think you can dance like Nijinsky? And obviously the answer is no. And then you learn that you can dance like Nijinsky, right? That's basically his work. But what I'm interested in and I'll wrap up because I think we're running out of time. What I'm interested in doing in using these examples is that you have within every practice, whether it's painting, whether it's dance, or whether it's cinema, a certain logic, a certain immanent logic of cultural creativity, of sharing of the ideas of what is appropriate and inappropriate. In other words, an entire system of propriety. You also have, immanent to that tradition, a claim of what it may mean to understand authorship, creativity, etc. With copyright law translating the entire domain of cultural practice into the terms of literary production, the dangers that you run into are not so much about whether it's only about access, whether it's about political economy. You have a realm in which an entire theory of culture, and one of the most active, because copyright is at the center in a way of the production of a cultural theory. You have the production of a cultural theory that does not know its object of regulation. Or if it knows it only in terms which are completely misguided, because it's about translation, it's not about recognizing the immanent logic of that practice. So if there is a way in which one could think about the future of intellectual property debates, I would contend that one would need to move out of and beyond, even while one maintains fights around questions of access, into actually arguing that what is needed is a system or a theory of cultural creativity which is in a way grounded within cultural creativity. So the question is not whether or not you create good law or bad law, because you can't judge that question. If you look at the Shivram Karan case, clearly on the one hand you could say, well, the reasoning on the second issue, namely of whether a dramatic work is the same as a literary work, was faulty or good, is one kind of an argument. There is a much larger problem here. The larger problem that you have is that what you are really producing is not so much good or bad law, you're producing good or bad cultural or aesthetic theory. So what would it mean to judge copyright law then on the imminent terms that it claims for itself. If copyright claims to be a theory of creativity, claims to be a theory of aesthetics, what does it mean to subject the legal principles to the claims of aesthetic theory or culture theory? And on that count, at the moment, it fails both in the copyright and in the copyleft tradition. The challenge for future research in this area, to my mind, comes in actually creating a logic of teaching IP, teaching copyright law, or doing copyright practice that is grounded very first and foremost from the logic of the practice. So it's not about teaching copyright law, it's about teaching copy in relation to dance, copy in relation to painting, or copy in relation to literary works. And only in that mode can we actually create a theory of copyright or a theory of culture which adequately speaks and addresses the question of what it might mean to understand both properties of culture as well as the cultures of property. So I'll stop there for now and open it out. I know it's a slightly technical talk, but I'm very happy to clarify any point that may, that you may have found.